Please be seated. Ladies and gentlemen, welcome. Welcome to the applicant, welcome to the respondent. The applicant can begin, please.
Madam President, honorable judges, my name is Valery Bogoev, and today it is an honor to appear before the International Court of Justice on behalf of the applicant, Esperia. Allow me to introduce my co-agent, Ms. Anna Maria Spasova. Your Excellencies, we would like to reserve 19 minutes of our time for my part in the pleading, in which I will address three main issues. First, that Esperia has standing to invoke the responsibility of Ionia for breaches of treaty-based obligations under both the 1951 Refugee Convention and the United Nations Convention on the Law of the Sea. Our second point is that our claim can proceed in the absence of Uenotria, the flag state. And my third point will be to address the breach of Article 87, referring to the freedom of navigation under the United Nations Convention on the Law of the Sea, on the merits. After I conclude, my co-agent will speak for 19 minutes and address the breach of Article 33 of the Refugee Convention on the merits and the respondent's counterclaim. We would like to respectfully reserve 2 minutes of our time for our rebuttal. Your Excellencies, Esperia has standing to invoke the responsibility of Ionia for breaches of fundamental obligations under the 1951 Refugee Convention, and more specifically, Article 33, referring to the principle of non-refoulement, which constitutes the very core of the Convention. The principle of non-refoulement is established as a fundamental obligation in international law and as well as that in international refugee law. That is specified by its customary character, its support in various international instruments, as well as by several highly noted publicists. A noteworthy mention is that as of April 2015, a number of 145 states are parties to the 1951 Convention, and a staggering 90% of all UN member states are parties to at least one international instrument which consists the obligation of non-refoulement within. A fundamental mention here is that from all these international instruments which contain the provision regarding the non-refoulement obligation, each contain a non-derogability, and this is affirmed by Article 42 of the Convention. Moving on, the fundamental character of the obligation has been also regarded by the European Court of Human Rights and several international criminal tribunals. Here, Your Excellencies, we wish to establish that by virtue of the fundamental character of the obligation of non-refoulement, which was breached by the respondents in the Venice Sea, is that we, as a state, wish to protect the common interest of all state parties to the Convention and consider ourselves to have standing to protect the common interest of a fundamental convention which safeguards fundamental obligations in the field of refugee law. Here, Your Excellencies, we wish to make a parallel, and by virtue of Article 48(1)(a) of the Articles on State Responsibility, we wish to affirm our right.
Counsel, where in the Refugee Convention does it say that third states can bring proceedings for breaches of Article 33?
Your Excellency, that a provision of that kind is not expressly found in the Convention. However, by virtue of Article 48(1)(a) of the Articles on State Responsibility, we have standing to invoke the responsibility of the respondents in the interest of the common, in the protection of the common interest, referring to the obligation. And
what's your authority for saying that Article 48(1)(a) is customary international law or otherwise applicable to the Convention?
Excuse me, could you...
What is your authority for saying that Article 48(1)(a) is customary international law or otherwise applicable to the Refugee Convention?
Your Excellency, the Articles of State Responsibility as conducted by the International Law Commission which is an UN-based organ and has been established in 1947, reaffirms the significance of the provisions contained, and furthermore, the character itself of the convention entails that it consists of obligations with the erga omnes partes character, which are of the interest of the international community of states as a whole. And this customary character is established by the virtue that at present a number of 120 states have implemented the non-refoulement obligation in their internal legislation, which points to their wish to safeguard the provision. And that being said, we wish to draw a parallel between the present case and the 2012 Belgium v. Senegal case, where this very court affirmed Belgium's standing on the basis that both parties to the proceedings are also parties to a convention which governs fundamental and key aspects of obligations and rights in the human rights sector, and namely the Convention Against Torture. And by that, we wish to elaborate that the fact that both state parties, as seen in the case, are parties to the Refugee Convention, have a common interest in safeguarding and protecting the essence of the Convention and its core, which can be found in Article 33.
Excuse me, Counsel, could you tell me whether the person concerned, the one which were on the boat, could be considered to be covered by the Refugees Conventions, even if they found themselves over in a neutral boat and they were supposed to be outside the country of nationality, but they were still on the boat of the nationality of the state where they're coming from? Thank you.
Thank you for the question, Your Excellency. We wish to elaborate that the people on board the MSI Protarchus can and should be considered as refugees, following on the fact that that the four necessary criteria, which are contained in the definition of the term refugee, are fulfilled at present, which has been qualified as to be sufficient. And to continue with the pleading, on the
Counsel, if I could ask you, could you turn your attention, when it's convenient for you, to the question of standing in relation to the allegations regarding freedom of navigation, because you've spoken a bit about standing in respect of the allegation of breach of the Refugee Convention, but obviously with a different substantive provision, we have different questions to consider as a court. Thank you.
Thank you, Madam President. Moving to the second point, and namely the standing under the United Nations Convention on the Law of the Sea, we wish to point the Court's attention to Article 87, where it is expressly provided that all states on the high seas, regardless of whether they are coastal or landlocked, enjoy the same rights to freedom of navigation. This notion is reaffirmed in customary character and can be affirmed can be strengthened by virtue of Article 123 of the same convention, which expressly provides that states bordering semi-enclosed seas, like the states we have in question today, have a higher duty of cooperation when it comes to the protection of the fundamental obligations and interests of all states considered in that situation, which boasts for a higher threshold of due diligence, which is also reaffirmed by Article 300 of the Convention, which is a reflection of the Pacta sunt servanda principle, and expressly provides that all state parties to the Convention have a duty to exercise their rights and obligations in good faith with due regard of the interests of all other parties, which is also the provision in Article 87, 1 and 2. Yeah.
Counsel, the freedom referred to in Article 87, freedom of navigation, is of long standing, much longer than the idea of obligations erga omnes. How did it become an obligation erga omnes and when?
Your Excellency, we wish to affirm that at present there exists no unilateral example on how a certain right obtains that status, but by virtue of this court's jurisprudence, and namely, we would point to the attention of the court paragraphs 33 and 34 of a judgment in the Barcelona traction case, it can be held that a certain right and or obligation obtains that status by virtue of its participation, if it can be found in general international law or a multilateral instrument like the United Nations Convention on the Law of the Sea, like in the present case, which also points to the fact that, which also strengthens the significant character of the obligation in question. And in saying that, we wish to elaborate further that we do not submit that freedom of navigation is an erga omnes right at present. We submit that it is an erga omnes inter partes obligation, and as such has to be fulfilled in good faith by all state parties to the United Nations Convention on the Law of the Sea, which reaffirms the common interest of all states, namely the ones on the Venice Sea.
Counsel, based on what you've said about the reason why there should be standing in this case in respect of the freedom of navigation allegation, I'm trying to think of a situation in which you would consider that a state that is a party to a convention, a multilateral convention, does not have standing. So give me, if you would, examples of the situation that is distinguishable from the situation in this case as you see it. What is the test that the court should apply to draw a line between this situation, in your view, and a different situation? Thank you.
Thank you, Your Excellency. The fact which distinguishes the Venice Sea states in particular and bows to the higher threshold of due diligence that they carry is reaffirmed by paragraph 5 of the case, which expressly stipulates the important economic, social, and cultural significance of the Venice Sea, as well as its regard as a fundamental point of navigation. And it is notable to conclude that all states bordering the Venice Sea have a common interest with regards to the provisions relating to that sea. And as such, it is a zone of interest to all 4 states.
So your case is not that there is a general right of all states in relation to each other's freedom of navigation, but this is specific to semi-enclosed seas.
Excuse me, could you repeat your question?
Your point is not that all states have an interest in each other's freedom of navigation under Article 87.
No, Your Excellency.
But that in a semi-enclosed sea, there is a special position.
Not exactly our submission, Your Excellency.
Well, what is your submission?
Our submission as the freedom of navigation, which comprises the freedom of the sea, or the mare liberum principle, is to be afforded and granted to all states, regardless of their participation in the convention. However, the fact that all 4 states are bordering the Venice Sea, a semi-enclosed, rather geographically small sea, reaffirms the higher threshold of due diligence when it comes to the interests in particular to that sea.
The question is one of standing, not due diligence. Due diligence assumes that there is standing.
Your Excellency, this is by virtue of our submission that as an erga omnes partes right, we have standing under the Articles on State Responsibility, and namely Article 48(1)(a). May I proceed? Continuing on to the next point, I wish to address that Esperia has standing to proceed with its claim under the United Nations Convention on the Law of the Sea, regardless of Oenotria's absence in the flag state. Regardless of the invoked indispensable third-party rule, Esperia still submits that its claim has standing to proceed. This is for several reasons. First, when in question we speak about erga omnes partes right, the indispensable third-party rule does not apply. Alternatively, the indispensable third-party rule provides that the court should evaluate a certain unlawful action of a state which is missing or has not consented to its jurisdiction. And in the relevant jurisprudence, at all times where the indispensable third-party rule was utilized, a party which conducted its international relations in an unlawful manner was either not present or had not consented to the court's jurisdiction pursuant to Article 36(2) of its statute. However, as we can see in our case, this is clearly not so, Your Excellency, for several reasons. First, as we read the text and the information of the case, all 4 state parties have consented to this court's jurisdiction. Furthermore, by virtue of the fact that Oenotria has not conducted an unlawful an unlawful exercise of its rights on the Venice Sea, there is no unlawful conduct which has to be analyzed in the present proceeding whatsoever. In stating this, I wish now to proceed with the claim regarding the breach of freedom of navigation under Article 87 of the Convention on the Merits.
Counsel, before you proceed to that, on this question of an absent third party, you referred to a rule. Could you state what you understand the rule to be? And then you indicated, if I understood it, that there was some sort of an exception to that rule that applied where the obligations at issue were erga omnes parties. What's your support for that proposition? Thank you.
Thank you, Madam President. By virtue of their status as erga omnes inter partes obligation, all states can proceed to safeguard the common interest. If we invoke the indispensable third-party rule with regards to obligations inter partes, we would find ourselves in a situation where a great sum of parties to an international instrument would not be able to safeguard the core provisions of that convention. And we base our submission on that premise, Your Excellency. And in saying...
Isn't that contradicted by East Timor?
Excuse me?
Isn't that contradicted by the East Timor case?
It is not, in our view, Your Excellency, because in that question there was unlawful conduct which had to be evaluated, and namely that of Indonesia, which was not present and additionally had not consented to the court's jurisdiction under Article 36(2).
The passage that I'm referring to in East Timor is the passage where the court said
that
the erga omnes standard or status of the rule invoked has nothing to do with monetary gold.
Excuse me, I misheard. What I meant to say is this court affirmed its standing, but nevertheless, the conduct in question was unlawful. And in that case, as we see, Oenotria was not the ship that intercepted, boarded, and subsequently pushed back the vessel back to Oenotrian waters, and as such was not the one that breached Article 87 of the Convention, which we reaffirm and submit that is based on several key points. I will elaborate on each subsequently. First, Ionia had no right to exercise its internal immigration laws on the Venice Sea. This is by virtue of Article 89 of the United Nations Convention on the Law of the Sea, which expressly provides that no state may subject any part of the high seas to its own sovereignty, and is later affirmed by Article 33 of the same convention, which refers to the contiguous zone, which is the furthest a state can implement its internal immigrations and custom law. Subsequently, the respondents breached Article 92 of the Convention, which refers to the exclusivity of flag state jurisdiction, which was reaffirmed by the Permanent Court of International Justice in its Lourdes case judgment, and can be found also in the Saga No. 2 case judgment before the International Tribunal for the Law of the Sea. Our next point in claiming that Ionia had no right to implement its internal legislation is based on the principle of priority of international law, which is additionally treaty-based in Article 27 of the Vienna Convention on the Law of Treaties, which, as we see in the clarification questions, all four states in our case are parties. This obligation and principles is further reaffirmed in Articles 3 and 32 of the Articles on State Responsibility. And in the interest of time, Your Excellencies, I will now address the submission of the respondents with regards to the excuse of the breach with a situation of distress. And here, Your Excellencies, I wish to point the Court's attention to the Annex 1.11 of the 1979 International Convention on Maritime Safety and Rescue, which, on the term and the definition of the word distress, points as follows: a situation wherein there is a reasonable certainty that a vessel or a person is threatened by grave and imminent danger and requires immediate assistance. No such imminent danger is found either in the case material or in the clarification question, and it is our submission that the respondents cannot justify their actions with an alleged rescue operation conducted by them. With this, Your Excellencies, I would like to conclude my part in the pleading. Thank you.
Madam President, honorable members of the court, my name is Anna Maria Spasova, and I have the honor to appear on behalf of the state of Hesperia as the second agent for the applicant. I will begin by showing that Ionia breached Article 33 of the 1951 Geneva Convention relating to the status of refugees. Then I'll move on to address the responder's counterclaim, namely the issues of jurisdiction and immunity. If it may please the court, I would like to start with the breach of Article 33 of the Refugee Convention on the merits. We will show, first, that the passengers on board of the MSA Plutarchus are refugees within the meaning of the Convention, and therefore entitled to the protection of Article 33, and second, that the respondent's actions constitute such a prohibited refoulement. Your Excellency, we would first like to emphasize that the person is a refugee as soon as they satisfy the criteria outlined in the definition, which would necessarily occur prior to any administrative law or domestic procedure that officially recognizes this status. Accordingly, Article 33 protects refugees whose status is yet to be recognized. The definition of a refugee is contained in Article 1 of the Refugee Convention, read in relation with the New York Protocol. Both of these instruments are ratified by the respondent, and there are 4 relevant criteria that must be cumulatively met. First, a person must be outside of their territory. Here, I would like to address your prior concern regarding whether or not they were in fact outside of their territory if they were still under the flag of one country. Your Excellency, while it is true that under the UNCLOS and maritime law, the flag of the ship is considered to be the same as the territory of a state, this is not the case with the meaning under the Refugee Convention, and this is clear in Article 11 of the same convention, which clearly distinguishes between a flag, the flag of a state and the territory of the state. Therefore, since according to the rules of treaty interpretation established by the Vienna Convention of the World Treaties, a treaty should be interpreted in context and in its entirety, we submit that the passengers on board of MSC Plutarchus were outside the territory of their state, and therefore they fulfill the first criteria. The second criteria is that the person must be outside of their territory due to a well-founded fear of being persecuted. Here, the case explicitly states in paragraph 11 that the passengers left to Anotria wishing to seek asylum. Prior to their departure, they were subjected to conditions which we submit were sufficient for them to reasonably fear persecution. These conditions include a media campaign lasting over 12 months and a viral editorial in the main newspaper, both of which openly encourage discrimination, as established in paragraph 8 and 9 of the case. The creation of a group, the Anotria Redistribution Group, which targeted them openly without any recourse from the government, as established in paragraph 9 and 10 of the case. And most importantly, the seizure of both movable and immovable property of more than 10,000 people, as established in paragraph 9 of the case. Here, I would like to address one of the issues raised by the respondent in their written memorial. They submit that seizure of property cannot amount to persecution within the meaning of the Convention. However, we submit first that the persecution in the present case is not limited to the seizure of property, but rather, as stated by the UN High Commissioner on Refugees, persecution can be present in cases where there is a combination of numerous harms, none of which are severe enough in themselves to constitute persecution, but taken together and keeping in mind with the general atmosphere of the state would amount to persecution.
Counsel, on the question of the location of these individuals on the ship that you addressed earlier, I'm having some trouble understanding the reasoning that you follow when you invoke Article 11 of the Convention, and I wonder if you could just go back to that and spell out more precisely why your reasoning should be convincing to the court. Thank you.
Yes, Lindsay. Article 11 contains an obligation to a state who has a person who is a refugee on board of a vessel that is under their flag. The obligation in question is for this state to provide this person access to their territory, therefore stating that the fact that he is under the flag of this state does not amount to access to territory as far as the Refugee Convention is concerned. Furthermore, I would note that there is not a single case in which any state has even attempted, let alone succeeded, in claiming that the person has failed to fulfill the criteria based on the fact that he is under another state flag, and that the UN High Commissioner on Refugee has issued an advisory opinion regarding the application of Article 33 on the high seas and did not even consider it necessary to address the issue of the flag.
it means that international shipping companies engaged in the tourist trade have obligations to every passenger who turns out to be a refugee, even though they've got nothing to do with the situation. Is that right?
Your Excellency, the obligation under Article 33 is not to provide asylum, it's not to return a refugee to the place where they're threatened, and it is an obligation that is binding on states, not on private merchant vessels. I would now like to return to the issue of the seizure of property as persecution. While we do maintain that this situation should be evaluated with all relevant facts taken cumulatively, we still maintain that seizure of property in and of itself can in fact amount to persecution. According to the UN High
The
Commission...
seizure here occurred from private parties. It wasn't seizure by the government. Does that matter?
No, Your Excellency. It is well established that acts of non-state actors can constitute persecution within the meaning of the Refugee Convention. This is stated by the UN High Commission on Refugees and is recognized by the Canadian Supreme Court in Attorney General versus Ward, by all EU states by virtue of EU legislation such as the Qualification Directive Article 6. I can even point you to a case in front of the Greek Administrative Court in which a decision of a lower body was overturned because the lower body did not recognize the actions of private actors as persecution, and it's also recognized by the US jurisprudence in Chang versus the Immigration and Naturalization Service, and by the Australia jurisprudence in S 2012 of 2003 versus the Minister of Immigration case. As far as the seizure of property is concerned, we submit that according to the UN High Commission on Refugees, any discriminatory act which amounts to consequences of substantial prejudicial nature to the person involved would amount to persecution. We submit that the seizure of both movable and immovable property would certainly reach that threshold. Furthermore, according to Professor James Hathaway, who is cited as a source by the respondent, seizure of property would amount to persecution if the result was a lack of adequate housing. As stated by paragraph 13 of the case, the passengers were homeless for weeks after they were returned. Therefore, this criteria is fulfilled. Furthermore, seizure of property is recognized in various jurisprudence. In the US, courts commonly cite seizure of property as one of the acts that an applicant for a refugee status must prove in order to qualify as a refugee, next to a threat to life or freedom or torture. This is done in the cases of Chang versus the INS, Mitev versus the INS, Bangranovsky versus the INS, Surita versus the INS, and Gonzalez versus the INS. Furthermore, this has also been recognized by Australian courts. The respondent relies on a case in a Canadian court, the Ramirez case. However, in that court, what the court took into account was the fact that the victim in question had access to other adequate housing and could find and would not be subjected to any seizure of property in the future. This is not the case here.
Counsel, if you assume for a minute, without deciding, that the individuals meet the definition of a refugee, you still confront the question of the extraterritoriality or not of that obligation in respect of non-refoulement. Could you address that, please? Thank you.
Yes, Excellency, I'll be happy to. Regarding the extraterritorial application of Article 33, the UN High Commission on Refugees, who is considered the most highly qualified publicist in the field of refugee law, has recognized and in fact has issued a separate advisory opinion solely on this topic, clearly stating that the scoprizione voci of Article 33 is not limited to the territory of the state. This is also supported by the jurisprudence of the European Court of Human Rights and in the Hirsi-Jamal v. Italy case, and by the Inter-American Commission on Human Rights in the Haitian Center Cell versus US case. I would like to return to the elements that are required in order for a person to be considered a refugee. The third relevant element is that this persecution must be based on one of 5 alternative protective grounds. These grounds include race and nationality. In the present case, the case makes it clear in paragraphs 6 and 8 that the persecution in question was based on the passenger's Western descent. We submit that this qualifies as a race as well as a nationality, and therefore the third element is fulfilled. The fourth and final element is that the person must be unable or unwilling to return to the country to which they are on the country of origin. Here, the case explicitly states in paragraph 12 that the passengers had to be forced to return. From that, we can conclude that they were in fact unwilling. Therefore, the passengers are refugees within the meaning of the Convention, since they satisfy all of the criteria and were entitled to the protection of Article 33. Article 33 states that no state shall expel a refugee in any manner whatsoever to the frontiers of the territories where his life or freedom would be threatened. Here, the case explicitly states that the Ionian Navy intercepted the vessel, did not permit it to continue in search of refuge, and returned it back to the frontiers of the European waters. We submit that this constitutes a clear violation of Article 33 and ask the Court to adjudicate accordingly. If it may please the Court, I would like now to move on to the responder's counterclaim and address the issues of jurisdiction and immunity.
Counsel, just briefly before you go to that, when I asked you about the extraterritoriality, you responded by referring the Court to the names of institutions that had made a decision that aligns with your position. But I'd like to ask you if you could please summarize the substance of your position. What is the substantive reason why you believe that the obligation applies on the facts of this case, leaving aside the identity of institutions that might have associated themselves with that position? Thank you.
Your Excellency, it has been established that a state is bound by its non-refoulement obligation in any case in which a state exercises jurisdiction. And what is understood by that is whenever a state exercises control and authority over the people in question. We submit that in the present circumstances, the case will pass any test of effective control that the Court wishes to apply. As far as the effective control goes, we will refer you to the case of Medvedev v. France in front of the European Court of Human Rights, in which very similarly, a private vessel was boarded, the crew was confined to quarters, and the court did found that it constituted an effective control. Our first submission regarding...
Counsel, that was a decision...
Pardon me?
That was a decision under the European Convention, which has its own jurisdictional rules. It wasn't a decision in relation to the Refugee Convention.
Yes, Your Excellency, it was a decision based on the non-refoulement, the Hirsi Jamal v. Italy is a decision on the non-refoulement principle in the European Convention of Human Rights. However, the Inter-American Commission on Human Rights case does concern the Refugee Convention, as does the opinion of the UN High Commission on Refugees.
And where is the non-refoulement obligation in the European Convention of Human Rights?
It is in Article 3.
Article 3 doesn't refer to non-refoulement.
It has been interpreted to include non-refoulement, however, not to refugees, but to people who are in danger of being tortured or subjected to treatment. However, the principle of non-refoulement itself, there is no reason to be interpreted differently. Our first submission regarding the counterclaim is that Mr. Quark-Celeste does not violate international rules of jurisdiction. We submit that our government's actions were legally justified under the UN Convention Against Torture. We submit that the Convention Against Torture, to which both states are parties, confers upon state parties a form of universal jurisdiction. Article 5.2 creates not only the right, but even the obligation of all states to establish jurisdiction in cases where there is alleged offender present in their territory, the so-called to extradite or persecute obligation. Article 6.1 and Article 7 contain similar provision. In the present case, Mr. Quark, the alleged offender, was present on the Spanish territory at the time of the arrest. We submit, first, that his conduct on both of the MSA Plutarchus, namely the violence, the threats, and the detention of Ms. Marighi taken together, do in fact amount to torture, and alternatively, even if this court should find that it is unable to definitively determine whether his conduct does amount to torture, that our government's actions were still justified under the UN Convention Against Torture, since our government acted within our margin of discretion in the face of a prima facie case of torture. Your Excellency.
Excuse me, Counsel. You said that there is a test of a prima facie evidence that there is some kind of torture has taken place. What is exactly the criterion that you use, and what is the basis for the criterion which would justify the exercise of jurisdiction on the part of your state?
Your Excellency, I will refer you to Article 6.1 of the Convention Against Torture that explicitly leaves a margin of discretion to the states to determine, and I quote, upon examination of the information available to it, whether the circumstances warrant taking the alleged offender into custody. What the Esperian authorities knew at the time was there was a serious injury inflicted by a public official in the context of an illegal detainment on the high seas. Therefore, we submit there was such a prima facie case of torture, since there was sufficient reason to suspect Mr. Quark. Furthermore,
Sorry, Councillor, aren't you conflating two different requirements? One which concerns detention and the other one the exercise of jurisdiction, in particular making preliminary inquiries in order to assess whether torture has taken place.
no, Your Excellency, Article 5.2 should be taken together with Article 6.1 and Article 7. Furthermore, I will refer you to the jurisprudence of this very court, pardon me, in the Belgium v. Senegal case, in which the court states that a state has failed to meet its obligation under the Convention by not initiating a proceeding as soon as they had reason to suspect that a person guilty of torture was present in their territory. Similarly, the Committee Against Torture has stated that a state would not be bound by its obligation only if there was not sufficient evidence to suspect that an act of torture had occurred. Therefore, we submit that the prima facie case is sufficient.
This requirement of sufficient evidence, it's important for detention. I wonder whether it is also important for starting proceedings, because otherwise, I mean, how can you start proceedings without having made some preliminary inquiries in which you identified whether there is some kind of evidence?
Your Excellency, if I understand your question correctly, my answer would be that Mr. Quark is actually not yet convicted in Esperance Court. Rather, he's held in detention and awaiting trial, and our authorities are still preparing a case against him, meaning they are still collecting evidence. Your Excellency, regarding torture, there are three cumulative criteria that must be met. They are established in Article 1 of the Convention Against Torture. First, the act must have been committed by a public official. In the present case, Mr. Quark, as a captain in the Ionian Navy, is undoubtedly a public official. Second, that the public official acted with intent in purpose. Since this element is not disputed by the respondent, in the interest of time, I would not address it and focus on the third element, severity. The case explicitly states that Mr. Marigi was punched very hard and suffered a serious injury. We submit there is no difference between severity and seriousness. Furthermore, we would refer you to the opinion of the UN Special Rapporteur on Torture, who has stated that the decisive criteria in distinguishing between torture and other forms of ill treatment should not be so much the severity of the pain or suffering, but the powerlessness of the victim, and that he has recognized punching as one of the acts capable of causing such severe pain and suffering. I would like now to move on to our last claim, namely that Mr. Quark...
But the event here was a single blow. If you say that a single blow of a person in detention is torture, then torture is, in the jails of the world, a universal phenomenon.
Your Excellency, we are not stating that a single punch is torture. We are stating that a single punch committed in these circumstances, in a detention on a woman on the high seas, where there was no higher available body offered to her for protection, taken together with the fact that this occurred in international waters, that there was threat to her and her friends, would amount to torture. Furthermore, not every punch committed in a jail would amount to torture, since it has to be committed by a public official, and that police beatings have been widely recognized by the Committee Against Torture as a form of torture.
With the condemnation of a public official, it can
Yes,
be,
Your Excellency.
so it's not always a public official has to do the punching.
It has
But
to be...
are you saying that torture is relative to location?
no,
So
Your Excellency.
you can have torture on the high seas, which would not be torture in a territory.
No, Your Excellency, I'm stating that when assessing torture, we should take both the physical and the mental consequences. And the fact that this occurred in high waters, in high seas, makes her particularly vulnerable because there is no near protection available. And that contributed to her fear. This was my submission. I do not think that violence committed on the high seas has a special meaning. I would like to summarize our last claim on immunity.
Please go ahead and just finish in a couple of sentences.
Thank you, Your Excellency. We submit that granting functional immunity to Mr. Quark in faces of an allegation of torture would be inconsistent with the Convention Against Torture, since the Convention, by definition, requires the involvement of a public official for the very crime for which it establishes universal jurisdiction. We base this on the Pinochet case, where this was exactly the decision of the House of Lords. We would also like to remind the Court that the Committee Against Torture has stated that they're in agreement with this decision of the Lords, and that they also state that there is no functional immunity for cases of torture under CAT. This is also the opinion of not one, but two of the UN Special Rapporteurs on Torture and on the UN Special Rapporteurs on Counterterrorism and Human Rights, and we submit that it is not inconsistent with the arrest warrant case or with the jurisdictional immunities case. Thank you for your kind attention.
Thank you to the applicant, and we'd like to hear now from the respondent, please.
Good morning, Madam President, Your Excellencies, may it please the Court. My name is Alexander Plachinta, and I'm honored to represent the state of Ionia, respondent in this case, together with my co-agent, Maxim Dorovy. I will speak first for 21 minutes and will address the first 3 submissions of respondent. Firstly, Ispiria does not have standing in the present case. Secondly, Ionia complied with the freedom of navigation under Article 87 of UNCLOS. And thirdly, Ionia also complied with the principle of non-refoulement enshrined in Article 33 of the Refugee Convention. Then I will give the floor to my co-agent, who will speak for 17 minutes and will address Ionia last 2 submissions. In consequence, we will be reserving 2 minutes for the rebuttal. If it may please the Court, I shall move to our first submission. After the incident in the Plutarchus took place, Ispiria brought the claim with regard to the freedom of navigation enjoyed by the Plutarchus, a yacht flying an Austrian flag, and also on behalf of 84 alleged refugees. There are 3 issues arising from these facts. Firstly, whether Ispiria can bring the claim if it is not injured by the alleged breach of the freedom of navigation and the principle of non-refoulement. Secondly, whether Ispiria can proceed with the claim under the freedom of navigation in absence of Inotua, the flag state of the Plutarchus. And thirdly, whether Inotua has validly waived its claim under UNCLOS. So turning to the first issue of standing, we've heard from agents for applicant that Ispiria has standing on erga omnes partes basis. In this regard, respondent recognizes that non-injured states may bring the claim before this court. However, as was stipulated by this court in 1966 Southwest Africa case, such a right to protect a common interest must be clearly granted by a legal instrument or a rule of law. In that case, this court assessed the jurisdictional clause of the 1920 Mandate Agreement, which, despite the broad formulation in view of the court, did not grant such a right for any state party to the Mandate Agreement to bring the claim in case of breach of the obligation under that agreement. In our case, we would like to emphasize that jurisdictional clauses, namely Article 286 of UNCLOS and Article 38 of UNCLOS, employ almost identical wording to that which was assessed by this court in Southwest Africa. And therefore, we invite this court to apply its decision in Southwest Africa and to decide that Ispiria does not have standing in the present case on erga omnes partes basis.
Excuse me, counsel. You remind the court of what it was said in 1966 about the mandates, but in that case, the court did not deny that Ethiopia and Liberia could have brought the case. They said it depended on what were the actual facts. The fact that in that particular case, no discrimination towards any Ethiopian or Liberian citizen was proved, made it, according to the court of that time, brought it to the conclusion that there was no standing and therefore that the claim was inadmissible. Now, if you transpose this reasoning to the Refugees Convention, you find yourself in a situation in which probably, according to your view, if I've understood the position of your states correctly, only the state of nationality of the people concerned would be able to bring a claim for a breach of the Convention on Refugees. But that state is exactly the state which is persecuting. So it's not likely to come and complain against non-refoulement.
Thank you, Your Excellency. In this regard, respondent recognizes that only that state which was specifically affected by the massive influx of refugees may bring the claim under the Refugee Convention. And in this regard, we refer this court to examples of Turkey and Lebanon who accepted during the 2015 more than 1 million refugees as such, while Ispira accepted only 84 refugees, and therefore Ispira cannot be regarded as a state which accepted and suffered from massive influx of refugees, and therefore it in no way had standing under the Refugee Convention.
But you relied on the Southwest Africa case as authority for the proposition that unless the treaty confers a right of standing, there's no right of standing. And you've just made an exception to that rule. On what basis do you make that exception and not others?
Pardon me, could you please clarify a question, Your Excellency?
You cited Southwest Africa for the proposition that the treaty has to confer a right of standing. Then you made an exception for large-scale incursions. What's the basis for that exception, and why aren't there others?
Let me clarify myself, Your Excellency. Our submission that the injured state under the Refugee Convention is the state which has accepted the influx or massive influx of refugees is premised on the idea that applicant cannot have standing as an injured state, and therefore we do not regard this submission as an exception to the rule which was laid down in the 1966 Southwest Africa case.
But could you tell us who would be an injured state in the case, supposing that what the applicant claim is right and these people were refugees? Who could bring a claim to this court?
We do believe that in our case, none of the states were indeed injured because, firstly, none of them accepted the massive influx of refugees, and secondly, those persons on the Votarkas were indeed not refugees but economic migrants, which will be demonstrated to this court during the third submission of respondent.
So, since 1966, you've had the Barcelona traction case, which expands standing. You've had other decisions of the court, and you've had the work of the International Law Commission in Article 48. Are you saying that we're stuck with the law as it was in 1966?
In this regard, Your Excellency, we do believe that the principle of non-refoulement enshrined in the Refugee Convention is not non erga omnes. As was illustrated by this court in this case, namely paragraph 34, the erga omnes obligations derive from general international law. And whilst the status of the non-refoulement as a norm of customary international law is highly disputed, Ispira cannot bring the claim that it has standing on erga omnes basis. As state practice demonstrates, by now the state of refuge can only expect from other state for assistance or help either directly or through international humanitarian organizations, and this by no means that all states which represent the international community may bring the claim in case of alleged breach of the of the non-refoulement principle. Turning to the second issue of standing, Ispira asserted that it could proceed with the claim under UNCLOS in absence of Ionia, because Inotua is not indispensable third party. In this regard, we do submit that the Inotua is indispensable third party, and therefore the court cannot exercise its jurisdiction over the present case. The concept of indispensable third party was developed by this court in monetary gold case, where in the dispute over Albanian monetary gold between Italy and the United Kingdom, the court declined to exercise its jurisdiction in absence of Albania, since the legal interests of that state formed the subject matter of the dispute. Equally, Ispira brought the claim which stems from Inotuan right of navigation, and to adjudicate upon this issue needs to decide upon direct right of Inotua in its absence and without its consent. Further, agents for applicant asserted that the status of the freedom of navigation as a norm erga omnes precludes the applicability of the indispensable third-party principle. In this regard, we refer this court to paragraph 29 of East Timor case decided by this court, where it stated that whatever the status of norm, it does not preclude the applicability of indispensable third-party principle. And therefore, we do submit that whilst Inotua is indispensable third party to the present dispute, Ispira cannot proceed with this claim under the freedom of navigation.
The problem with monetary gold was that the court had to decide on the responsibility of Albania in its absence. But it's not suggested here that Oenotria has committed any wrongful act. There's no issue of responsibility of Oenotria in this case, so why has monetary gold got anything to do with it?
We do submit, Your Excellency, that in monetary gold it was rather the right of Albania to seek the compensation for monetary gold rather than its international responsibility, and therefore we do invite this court to apply its decision in monetary gold case. Apart from that, if this court will, should this court decide that Innovative is not an indispensable third party, it would prevent it from protecting its own right under the Freedom of Navigation enshrined in Article 87 and 92 of UNCLOS.
Counsel, if I could take you back to the general standing question. If I understood your opponents, they place emphasis on Article 48 of the draft Articles on State Responsibility. Are you suggesting that this court should ignore that article, what it says, and if so, on what basis should we do so?
In this regard, we do submit that the Article 84 with regard to obligations ergo omnes partes is not the customary international law now. It is merely a progressive development of international law, as was stated in the commentary to this article by the International Law Commission. Turning to the
court applied the ergo omnes partes principle in the case involving Belgium and Senegal. Surely it's a bit late to argue that it doesn't exist.
Yes, Your Excellency, it applied this norm. However, we should distinguish this case from our case because the obligation in question which was decided in obligation to prosecute and extradite was different from obligations which are allegedly breached in our case. Proceeding to the third issue of standing, respondent submits that the statement of Ionian Prime Minister could indeed constitute the waiver of claim with regard to the freedom of navigation. As was stated in the Europhosphate case, a waiver of a claim is a clear and unequivocal declaration made by a competent authority of a state whose rights were affected. In this regard, we do submit that and emphasize that the Ottoman Prime Minister, after the incident at Plutarchus took place, thanked Ionian government for the measures taken against the Plutarchus. Apart from that, no actions were followed on part of the Inotua after the declaration by Prime Minister was made. And therefore, we do believe that this submission shall be regarded as a waiver of claim under the freedom of navigation, and it also bars respondent from pursuing claim under the freedom of navigation. And if there are no further questions regarding the first submission of standing, we'll turn to the merits and to the second submission of respondent. There are two issues arising from the facts. Firstly, whether Mr. Clark had reasonable suspicion of piracy on part of the Plutarchus, and secondly, whether return of the Plutarchus back to Northern waters was legal. Turning to the first issue, respondent referred this court to Article 110 of UNCLOS, which codifies the international custom that any warship may board a foreign vessel which is reasonably suspected of piracy. In this regard, we do recognize that by the time of boarding, Mr. Clark could have reasonable suspicion that the Plutarchus could have been hijacked and controlled by pirates for the following reasons. Firstly, the Plutarchus was a perfect target for pirates because it was a luxurious yacht with possibly rich persons aboard. And secondly, it sailed in the deserted area of the Venus Sea, where it could be easily hijacked by pirates. These circumstances assessed together allowed Mr. Clark to have reasonable suspicion of piracy and to comply with Article 110 of UNCLOS, and therefore the boarding of the Plutarchus was legal.
Sorry, Counsel, but if you applied those standards, wouldn't it be easy for any warship to stop anything, any ship navigating on the high seas? What was more specific that justified this kind of action? Was it Mrs. Ambridge's appearance or some other element?
We do understand your concern, Your Excellency. In this regard, we draw attention of this court to the fact that the Plutarchus was a luxurious yacht which was really unfamiliar to this deserted area of the Venus Sea. And furthermore, the Plutarchus in this area could be easily hijacked, and this situation differs from any other situations which Your Excellency may be referred to. And therefore, we do believe that there were reasonable suspicion of piracy on part of the Plutarchus. And turning to the second issue presented during this submission, applicant asserted that
had there been any incidents of piracy in this area, what was the concrete evidence that this ship might have been the subject of a piratical attack? Just because it was a nice ship doesn't make it a target for naval captains of other nations.
Indeed, Your Excellency, there is no note in the facts of the case that this area was known for piratic attack. However, our submission is relied on the type of the ship and on the area, and in this regard, we refer this court to the Alondra Rainbow incident, which involved the tanker in the Malacca Straits, which was hijacked and controlled by pirates. In that case, the type of vessel did not prevent the boarding crew from reasonable suspicion of piracy.
But everyone knows that the Straits of Malacca are infested with pirates. They have been for 200 years, and possibly longer. Where's the evidence of piracy in this case? I suppose your answer is there is no evidence.
We also drew attention to this court that states had the duty under UNCLOS to cooperate in suppression of piracy, and therefore we found it reasonable to Mr. Clark to reassure that there was no piracy, that there was or not piracy on the Plutarchus, since otherwise it would be a possible breach of the duty to cooperate in order to suppress piracy. Turning to the next issue, applicant asserted that a respondent breached international law by escorting the Plutarchus back to Northern waters. In this regard, we do submit that the escort of the Plutarchus was performed solely in order to ensure the compliance with obligations enshrined in Article 98 of UNCLOS, that is, the duty to rescue. This article codifies the international duty that any shipmaster shall, at all reasonable speed, to proceed to a ship which is in this situation in distress. In this regard, we do submit that Mr. Clark had reasonable certainty that the Plutarchus was in that situation. Firstly, the Plutarchus sailed in the very dangerous area of the Venus Sea, infamously known for submersible canals, unpredictable currents, and shallow waters, as was underlined in paragraph 4 of the facts of the case. Apart from that, since time immemorial, vessels of any nationality avoided crossing this particular area, and therefore we do submit that these circumstances allowed Mr. Clark to have reasonable certainty that the Plutarchus was in situation of distress, and therefore he reasonably performed his duty to rescue by escorting the Plutarchus back to Northern waters.
But counsel, doesn't the obligation under Article 98 require an indication on the part of the vessel in question that there is a need of assistance?
No, Your Excellency, under Article 98 of UNCLOS, the shipmaster of a rescued vessel should be merely informed of the situation of distress, and we do submit that the term informed implies that there is no need for a formal request made by a rescued vessel, but there should be a demonstration of appearance of a vessel which shall be in distress. Turning to our third submission regarding the alleged breach of the Refugee Convention, there are two issues arising from these facts. Firstly, whether persons in the Plutarchus were economic migrants or refugees, and secondly, whether the principle of the non-refoulement applies in the high seas. Turning to the first issue, respondent submits that the persons in the Plutarchus were merely economic migrants who fled to Austria exclusively for economic reasons. It should be firstly stressed that since 1945, the Austrian economy has been seriously stagnating and almost collapsed, and this fact has forced migrants from Inotra to cross the Venus Sea on their way to prosperous states of Ionia and Vestia even before the incident of the Plutarchus took place. Further, if those persons in the Plutarchus indeed faced persecution, they could flee to the neighboring state of Spira, which was closer, rather than cross the Venus Sea on their way to Ionia. The second argument is that Refugee Convention protects from prospective persecution, that is, persecution in future. In this regard, the Federal Court of Canada in Ramirez's case held that the single episode of property confiscation did not amount to act of persecution, because Nicaraguan authorities in that case did not prevent affected Nicaraguans from obtaining new housing. Also, if the alleged persecution was committed by non-state agents, this requires high threshold of proof. In our case, the alleged act of persecution, that is, expropriation, could not occur in future because of its very nature. Apart from that, there were no fundamental rights of affected Inotrans which were violated in order to persecution to be severe enough. Apart from that, the danger stemmed from non-governmental ORG, not from Inotra itself, and affected Inotrans did not even seek any protection from their government. They merely fled to prosperous state of Ionia and Vestia. These circumstances allows respondent to submit that the persons in the Protarchus were economic migrants and not refugees within the meaning of the Refugee Convention.
You say that there can't be persecution if the persecution has already occurred. So someone who's living in poverty on the street can't be persecuted because they've already lost all their property. That's a rather curious idea of persecution.
In this regard, we reaffirm our reference to the Ramirez case, where it held that economic persecution shall be severe enough and systematic enough. In our case, it wasn't systematic enough because it was committed only once, and the fact that all the 10,000 affected Inotuans stayed in the Inotua indicates that Inotuan authorities did not further expropriate their property from them, and therefore...
They had no property left to expropriate. They were living in destitution.
We do believe
everything is fine. Destitution is okay.
We do believe since the time of persecution, they could have obtained new property, and it is for sure because they need to make their living, and by the fact that that they stayed in Inotuans and did not escape to the safer state of Hesperia, it indicates that they obtained new property, and therefore that persecution was not severe enough to be regarded as persecution indeed. Turning to the second issue, we do submit that the principle of non-refoulement does not apply in the high seas. Article 33 of the Refugee Convention is not clear on this matter. Therefore, we invite this court to have recourse to the travaux préparatoires to the Refugee Convention. Thank you. The travaux préparatoires of the Refugee Convention confirm that its application is limited to the territory of a state, and this is supported by the practice of states which are specifically affected with issues of migrants and refugees, including the United States, the United Kingdom, and Australia. And therefore, we do submit that this principle is not applied on the high seas, and this concludes arguments of mine, and may it please the Court, Your Excellency. Thank you.
Madam President, honorable members of the court, may it please the court. My name is Maxim Dvorovy, and today I also appear on behalf of the respondent state, Ionia, in the interception and Divinus Sea dispute. For the next 17 minutes, I will address the counterclaims of Ionia. Firstly, I will show that Hesperian arrest and detention of Mr. Clark in the present case breached international law rules on immunities. And secondly, I will prove that Hesperian domestic law extending its criminal jurisdiction towards this case was contrary to international law, notwithstanding the Torture Convention. With regard to our first counterclaim, we will emphasize that the acts of Mr. Clark in the present case cannot be regarded as torture. Not denying that his acts constituted ill treatment, we will submit that the functional immunities of Mr. Clark in the present case are in no way influenced. Your Excellencies, Ionia respectfully disagrees with the position of the applicant state as to the legal qualification of the acts perpetrated by Mr. Clark. While Hesperia in the present case insists that the purpose of the treatment is the key distinguishing factor between torture and ill treatment, we submit, relying on Delaled's judgment of ICTY, that severity of the pain or suffering by the victim is the key criterion which shall be taken into account. What is more, this notion was also supported by the European Court of Human Rights, which stated in Salmuni versus France case that the special stigma of torture shall only be attached to deliberate inhuman treatment causing very serious or cruel pain or suffering. And to elaborate our argument, we would like to present to this honorable court different examples of torture which were qualified as torture by international bodies. Such examples include waterboarding, rape, Palestinian hanging, mock amputation with electric saw, and beating resulting in removal of testicles. Indeed, the threshold of torture has been lowering in recent years. However, the case with probably the lowest threshold of torture which we can present to this honorable court was decided by the Committee Against Torture, and this case is Dragan Dimitrievich versus Serbia and Montenegro. And in that case, for the act to qualify as torture, the act itself constituted a beatings over the 5 hours of detention. In the present case, there was only a single punch, and even taken together with 24 hours of detention, it cannot amount to the threshold of severity which is established for torture. In the written submissions, our opponents also rely upon the mental suffering of the victim and on the arguments with regard to the threat of torture, which can constitute torture. However, in the present case, as is stated in paragraph 12 of the case problem, there was no threat of torture, but merely a threat of further detention of Ms. Amarigi. Therefore, we do submit that in the present case, the acts of Mr. Clark were not prima facie torture. However, we will not deny that the acts of Mr. Clark in the present case...
I'm sorry. You say there was a single act of a single punch, but she was in detention for 24 hours and she could have been in detention for longer. Why wasn't she apprehending further mistreatment in that situation?
Your Excellency, in the present case, we can recognize that incommunicado detentions can be recognized as the form of ill treatment. However, to qualify as torture, they need to be prolonged, and as was established by European Court of Human Rights in Dikme versus Turkey case, 16 days of incommunicado detention may qualify as torture. In the present case, we can distinguish it from the Dikme versus Turkey since the detention lasted for only 1 day. However, we will not deny that in the present case the acts did constitute ill treatment, since even 2 slaps were recognized by Committee Against Torture in Osmani versus Serbia case as constituting inhuman treatment. However, such a qualification of the acts of Mr. Clark does not preclude them from being covered by functional immunities.
Sorry, Counsel. Do you concede that if the acts in question were acts of torture, there would be jurisdiction on the part of the applicant state to act against Mr. Clark?
Yes, Your Honor. Had this act been qualified as torture, they would have had prescriptive jurisdiction over the present case. However, as we will submit further, they applied their domestic law establishing prescriptive jurisdiction contrary to the other norms of international law, including the norms of the United Nations Convention on Law of the Sea and the principle of nebis in idem.
Excuse me, I want to follow the previous question. If there is jurisdiction on the part of the applicant state, wouldn't that jurisdiction have to be exercised even before torture has been ascertained, as they claimed when there's a suspicion of torture? You exercise jurisdiction, you come to the conclusion that perhaps there isn't torture, but the state is justified in exercising jurisdiction.
We may consider in the present case that the exercise of jurisdiction was justified on behalf of Ispiria. However, still, the exercise of jurisdiction in the present case was contrary to the norms of international law. And therefore, despite it being justified by their domestic law, it was still wrongfully applied. And continuing with the argument on the immunities, Your Excellencies, we submit that functional immunity is granted to all state officials which act on the state's behalf and extends to all of their acts performed in official capacities. And
before we come to immunity, there is jurisdiction. Why didn't Ispiria have jurisdiction under its national law? The Torture Convention is non-exclusive. There may be other grounds for jurisdiction. And the captain was seized in Ispiria.
Your Excellency, Ispiria may have jurisdiction in the present case by virtue of the norms of the Torture Convention, namely its Article 5, which was submitted in the present case. However, the exercise of their jurisdiction should have been dependent on the qualification of the acts perpetrated by Mr. Clark. The obligations under Article 5 of the Torture Convention are only applicable to torture, but not other forms of inhuman treatment.
Yes, I understand that, but my question is a different one. Why didn't Esperia have jurisdiction under its national law, which was broader than the Torture Convention?
Esperia might have jurisdiction under its domestic law since Article 5.3 of the Torture Convention does not explicitly state, Article 5.3 of the Torture Convention allows to extend jurisdiction further from the forum deprehensionsis basis. However, in the present case, as we will submit further, the law was nevertheless applied contrary to international law. And turning back to the immunities stage, Your Excellencies, we submit that in the present case, Esperia breached immunities of Mr. Clark. Upon stating that Mr. Clark was not entitled to immunities, they rely upon two arguments. The first argument is that granting of immunity is incompatible with the Convention Against Torture and constitutes an implied waiver of immunity. However, they rely precisely on the opinion of some lords in the Pinochet case. What we can submit in the present case that other lords, including Lord Gough and Lord Cope of Craighead, in that very same decision, they also stated that the situation does not suffice to say that the signature and ratification of the Convention Against Torture amounts to the valid waiver of immunity. Moreover, the view that the signature and ratification of the Convention Against Torture does not amount to the waiver of immunity is supported by the courts of the United States in Ferdinand Marcos case and Argentine Republic versus Amaranta Hess decision. The second ground upon which the applicants relied in the present case in their written submissions was the very nature of the offense. And while we do concede that, as the present state of the law shows, there exists the international crime exception from the immunity, in the present case, the conduct of Mr. Clark did not constitute an international crime. Since in the present case, his conduct should be qualified merely as ill treatment, and this ill treatment was perpetrated outside the context of crimes against humanity, it cannot qualify as an international crime in the present case.
Counsel, if I understand what you just said, you're stating that there is some sort of an international crime exception, but the conduct here doesn't rise to the level of international crime. So what's the nature of the exception that you appear to recognize, and why does it exist? Thank you.
In Lozano versus Italy case, it was established that crimes against humanity and war crimes and their perpetrators cannot be entitled to immunities, and this was recognized by Italian court as the norm of customary international law. What is more, such an exception is also widely supported by the academics of different nationalities.
What's your position then in relation to this court's decision in the Germany-Italy case? Because their immunity was recognized, notwithstanding that everyone accepted that the underlying acts were crimes, serious crimes.
I understand your concern, Your Excellency. However, in that very same decision, it was stated that this case applies solely to the state immunity, but not to the immunity of state officials under international law. And therefore, jurisdictional immunities of the state case is distinguishable from the case at the present.
States can only act through their officials. And if a serving officer of a state is prosecuted, is sued rather, in the courts of another state, the effect is to impede the state. Otherwise the state can't act. It has to act through agents.
Yes, Your Excellency. However, there is no still recognized decision on the international scale which could have definitely proved and stated the exceptions from the immunity of the state officials, and therefore we invite this honorable court to distinguish this case from jurisdictional immunities of the state case and to apply the approach followed in Lozano versus Italy. And accordingly, Your Excellencies, since Mr. Clark was a state official of Ionia who was applying its immigration laws on what MSY Plutarchus, his acts in the present case were official and thus covered by functional immunity. And if Your Excellencies have no further question with regard to the first counterclaim of Ionia, we would like to present our second counterclaim concerning jurisdiction. As stated in paragraph 14 of the case problem, Ispiria passed its domestic law extending its criminal jurisdiction to all violent crimes perpetrated by nationals of all states, and thus it established universal jurisdiction. What we will submit in the present case that this law was applied contrary to the Convention Against Torture, contrary to the provisions of the UNCLOS, and contrary to the principle of nebis in idem. As we have already stated, the Convention Against Torture specifically extends the provisions and the obligations under Article 5 of the Convention solely to torture. Therefore, the reliance of the applicants in the present case towards the Convention Against Torture is not valid, and the situation is not covered by the Convention Against Torture. Therefore, the applicants in the present case applied their domestic law contrary to the norms of that convention. Moving to our alternative argument, we would like to rely upon a still valid principle established in the Lotus judgment, that is, the extraterritorial jurisdiction of the states can only be limited by specific prohibitive rules of international law. And in the present case, we can find those rules in Article 97 of the UNCLOS, which prescribes that only the flag state or the state of the nationality of the perpetrator possess jurisdiction in cases involving penal or disciplinary responsibility of the master of the ship arising from the incidents of navigation.
Excuse me, Counsel, you, by defining what happened on board ill-treatment or torture act on board the yacht as an incident of navigation, aren't you really saying that anything that happens on board of a ship is an incident of navigation, even if no other ship is involved? Supposing Mr. Clark had been parachuted to the boat, would that be also an incident of navigation because he found himself on board the Miss Amerigi's boat? Thank you.
Your Excellency, in the present case, first of all, there was a boarding, and the boarding resulted in the ill treatment towards Miss Amerigi. We, upon stating that this was an incident of navigation, we rely upon the broad definition of incident of navigation, which was given by the International Maritime Organization and is currently supported by Italy in Enrico Alexiei case pending before the Permanent Court of Arbitration. And this broad notion of incident of navigation means that any maritime incident of navigation is any maritime casualty which causes serious injury to the national of another state. And in this regard, since the injury suffered by Miss Amerigi was serious enough and the incident was perpetrated on the high seas, there exists an incident of navigation in the present case. Accordingly, Ionia possesses both the flag state and the state of the nationality criteria in the present case, and should have enjoyed exclusive jurisdiction over Mr. Clark in the present case. And, Your Excellency, we would also like to briefly mention our last argument concerning the nebis in idem principle. In the circumstances similar to our case, it was applied by Spanish Audiencia Nacional in Peruvian genocide case, where Spanish courts were specifically barred from pursuing any action against the perpetrators of Peruvian genocide on the basis of universal jurisdiction, since Peruvian courts have already conducted their own proceedings on the matter. In the present case, Ionia conducted its own disciplinary proceedings under its national law, which resulted in 3-month suspension of duties of Mr. Clark. We submit that these proceedings were sufficient under the torture declaration, and therefore they do not qualify as the chemtrail exception to the nebis in idem principle. Accordingly, by extending its jurisdiction in the present case, Ionia breached nebis in idem principle, and therefore...
Could you tell me where you get the nebis in idem principle from? Because its articulation in the international covenant is relative to the particular state. It's not a rule allocating jurisdiction between states, it's a rule about double jeopardy within a single state. Where are you getting a broader principle from?
Your Excellency, may I answer your question? Your Excellency, certain sources of international law show that the principle of nebis in idem can be applied between different states and different proceedings, and such sources include the ICC statute, the Schengen Convention, and also the cases of British and Canadian courts, which state that principle of nebis in idem also applies between two states. If Your Excellencies have no further question, I would like to finish my argument. May it please the court.
The court will now hear rebuttal from the applicant, please.
Your Excellencies, in exercising our right of rebuttal, the government of Esperia wishes to address solely the issues of the extraterritorial application of Article 33. The respondent cited the travail préparatoire and the ordinary meaning of the article as a source of interpretation to submit that Article 33 does not apply on the high seas. However, the UN High Commission on Refugees' opinion that we cited earlier has examined both the travail préparatoire and the ordinary meaning of the Convention and decided that and has issued an opinion that contradicts the submission of the respondent, and therefore he does not agree with their conclusion. The respondent did not cite specific cases in their pleading, however, they did so in their written memorial. The U.S. court they referred to in the pleading, we assume, is the SEO versus the Haitian Centre case. However, that case has also been examined by the Inter-American Commission on Human Rights 2 years later in the decision that we submitted, the Haitian Centre for Human Rights versus the United States, in which the Commission concluded that the U.S. court has erred in its judgment and instead agreed with the UN High Commission on Refugees in paragraph 157 of the case and recommended that the U.S. pay damages. As far as Australian jurisprudence goes, in their written memorial, the respondent quotes the Ibrahim versus the Minister for Migration case. However, that case did not concern extraterritorial application of Article 33, and the court did not actually state that they believe that it is limited to the territory of the state. Rather, they just quoted the SEO decision by the US court, and at no point did they agree with it. The respondent also stated that there is a UK jurisprudence that supports their claim. They have provided no such source in their written memorial. However, we expect that they are referring to the immigration officer at the Prague airport decision. However, we submit that this decision does not support their submission because even in this case, some of the judges in the majority did agree that Article 33 has extraterritorial application. It simply did not, may I finish my sentence? It simply did not fulfill the criteria of effective control in that case. Thank you for your kind attention.
Thank you, counsel, and we'll proceed next to the rebuttal. Thank you.
Madam President, Your Excellencies, we would like to rebut 2 points raised by applicant. Firstly, applicant asserted that United Nations High Commissioner for Refugees in its advisory opinion supported the extraterritorial application of the non-refoulement. In this regard, we do submit that the High Commissioner for Refugees is not the chief interpretative body of the Refugee Convention, and apart from that, its advisory opinion cannot be regarded as a primary rule of international law. Secondly, applicant asserted that the sale case was overruled by the Inter-American Committee on Human Rights. In this regard, we also invite this court to apply other cases which represent the state practice of specifically affected states worldwide. In European Human Rights Centre case, the House of Lords of the United Kingdom supported the approach taken by the Supreme Court of the United States, and also High Court of Australia also supported that view. And apart from that, in the travaux préparatoires, the drafters of the convention were clear in their intention to limit the applicability of the non-refoulement. That it was the proposition of the representative of the Netherlands, and that interpretation was approved by the president of the committee, which drafted the convention, and was put on the record. Thank you. It concludes my argument.
Thank you, counsel. That's the oral proceedings in this case, and the court will now retire for deliberations. Thank you.
done, teams. May I please invite everybody to go outside? There's a bit of water, a bit of coffee, but please could you also then go to the stairs at the front of the Peace Palace, and we will try to take a very nice group picture of all of you. Yeah?